Hello, and welcome to Module 1 of the Indian Child Welfare Act, or ICWA, Active Efforts Learning Series, an introduction to the Indian Child Welfare Act and active efforts. To facilitate this learning experience, we have gathered questions from state child welfare supervisors and workers specific to the content of this module. Let's begin with a question about the Indian Child Welfare Act.
I'm not clear why I have to manage cases differently for American Indian and Alaskan Native or AIN families on my caseload. Why did they create ICWA in the first place?
ICWA is a federal law that governs state child welfare practice in several ways. ICWA provides guidance to states regarding removal and out-of-home placement of AIAN children and youth. ICWA provides guidance regarding the handling of child abuse and neglect and adoption cases involving Native children, and sets minimum standards for the handling of these cases. The Act requires states to use active efforts to provide services and supports designed to prevent the separation of AIAN families. These active efforts must be tailored to each child and family. ICWA came about in 1978 as a response to a crisis affecting AIAN children, families, and tribes. Studies showed that state child welfare and private adoption agencies separated large numbers of these children from their parents, extended families, and communities. Research by the National Indian Child Welfare Association shows that prior to ICWA, 25 to 35% of all Native children were being removed. Of these, 85% received placements outside of their families and communities, even when fit and willing relatives remained available. Lawmakers designed ICWA to stop the most long-standing and egregious removal practices targeting AIAN children. Among the added protections for these children, ICWA requires caseworkers to take the following steps when managing a case. 1. Notify the child's tribe and parents of the child custody proceeding. 2. Work actively to involve the child's tribe and parents in both court and case proceedings. 3. Provide active efforts to the family. And 4. Identify a placement that fits under the ICWA preference provisions.
Okay, that makes sense. I can see why changes were needed with so many AIN children entering foster care. Haven't things changed though? Why do we still need ICWA?
Let's start with a bit of history. Native family separations have typically lacked justification. For example, one 3-year-old Sioux child was removed from her family on the state's belief that an Indian reservation is an unsuitable environment for a child. In fact, the same authorities who forced Native families onto reservations at gunpoint later told them that they lived in a place unfit for raising their children. Unfortunately, although ICWA has sparked progress, out-of-home placement still occurs more frequently for AIAN children than the general population. According to the National Indian Child Welfare Association, Native families are still 4 times more likely to have their children removed and placed in foster care than their white counterparts. So, despite the advances over the decades, AIAN families still need ICWA's protections. They also need support from child welfare and other collaborative partners within healthcare, substance use treatment, courts, home visiting, and community-based agencies to gain a deeper understanding of ICWA. As recently as 2023, legal challenges to ICWA argued that Congress did not have the power to create these protections for AIAN families. The Supreme Court decision in Brackeen v. Holland affirmed that Indian tribes remain independent sovereigns with the exclusive power to manage their internal matters, and that the Constitution reflects an understanding that tribes enjoy a power to rule themselves that no other governmental body, state or federal, may usurp. Justice Neil Gorsuch, in his concurring opinion, documented key events that led to the enactment of ICWA. The ICWA did not emerge from a vacuum. It came as a direct response to the mass removal of Indian children from their families during the 1950s, 60s, and 70s by state officials and private parties. That practice, in turn, was only the latest iteration of a much older policy of removing Indian children from their families, one initially spearheaded by federal officials with the aid of their state counterparts nearly 150 years ago. The first mass effort to separate AIAN families were the creation of boarding schools. The Carlisle Indian Industrial School opened its doors in 1879. Carlisle's head summarized the school's mission this way: "All the Indian there is in the race should be dead. kill the Indian in him and save the man. Carlisle became the model for what would become a system of 408 similar federal institutions nationwide. As late as 1971, federal boarding schools continued to house more than 17% of the Indian school-age population. As federal boarding schools closed their doors, states gained new responsibilities. Through the 60s and 70s, Indian child removal reached new heights. Surveys conducted in 1969 and 1974 showed that approximately 25 to 35% of all Native children were separated from their families. Justice Gorsuch's final words answer your question about whether we still need ICWA. He stated, quote, "Our Constitution reserves for the tribes a place, an enduring place, in the structure of American life. It promises them sovereignty for as long as they wish to keep it. In adopting the Indian Child Welfare Act, Congress exercised that lawful authority to secure the right of Indian parents to raise their families as they please, the right of Indian children to grow in their culture, and the right of Indian communities to resist fading into the twilight of history." All of that is in keeping with the Constitution's original design.
I understand that I need to provide more support for AIAN families. Can you clarify what qualifies as active efforts?
Yes, authorities removed many AIAN children from their homes because of poverty, parental joblessness, substandard housing, and other situations that providing families with services and supports could have resolved. The active efforts requirement helps ensure that parents receive the services they need while their children remain in their care. In addition to preventing family separation, active efforts can also help families quickly and safely reunify pending court intervention. These active efforts, which focus on the quality of the actions taken, must be affirmative, thorough, and timely. Active efforts are different than reasonable efforts. Active efforts means not just identification of the problems or issues, but energetic efforts that show an active attempt to assist in alleviating the problems or issues that led to removal of the child from the family. A rule of thumb is that active efforts is to engage the family, while reasonable efforts simply offers referrals to the family and leaves it to them to seek out assistance.
Can you also provide concrete examples of actions I can take that would meet the active efforts standard?
I would be happy to. There are many benefits to state and tribal consultation for systemic improvement. At the case level, establishing a trusting and collaborative relationship with tribal social workers who have knowledge of the family, as well as community supports and resources, is a key first step. You can demonstrate active efforts by asking AIAN parents to share their experiences of trying to navigate multiple systems while often feeling helpless as they try to keep their family intact. If you can reflect on the time in your own life when you felt helpless and think about what you needed to regain balance, you can begin to identify options for these parents as they embark on their own healing journey. Culturally appropriate services in the child welfare context could include those that support healing for each family member, such as pastoral counseling that incorporates a holistic approach while focusing on spirituality, and tribal faith healers within the tribe who utilize prayers, ceremonies, sweat lodges, and other interventions. You might even want to work on understanding how unhealed trauma can affect parental choices and actions in your own practice. Examples of active efforts include identifying appropriate culturally specific services and actively helping the parents obtain them, identifying, notifying, and inviting representatives of the child's tribe to participate in providing support and services to the AIAN child's family. Support includes family team meetings, permanency planning, and resolution of placement decision, and conducting a diligent search for the child's extended family members to help provide family structure and support for both the child and parents. These examples of active efforts reflect tribal child welfare best practices, but are not meant to be an exhaustive list. We use state agency for the office seeking removal of a child into custody or with current custody of the child. ICWA puts active efforts obligation and responsibility on state agencies. ICWA does not put this obligation or responsibility on tribes or tribal programs. Despite ICWA's mandate for active efforts, follow-through remains a problem nationwide. National studies have found active efforts documented in only 66% of case records, 67% of pretrial or adjudication hearings, and just 21% of disposition hearings.
How will I know if I am achieving active efforts? What can I do throughout the case so there are no surprises down the line? Does my supervisor decide? Or the judge? Or both?
Let's unpack this a bit. Agency workers and courts should ask whether they have truly taken active steps to provide services and programs to the family. Active efforts should be reviewed at every court hearing. Courts must conclude staff made active efforts before ordering foster care placement. These steps will help avoid unnecessary delays in achieving reunification with the parent or other permanency for the child. Instead of waiting for the courts to ask, remain proactive and routinely provide information in every court report on how you plan to implement active efforts. Remember, state agencies should note that state courts must find that active efforts were provided to make an out-of-home placement for an AIAN child. For example, if a parent initially refused substance use disorder treatment despite an agency's active efforts to provide services, a court could find these efforts satisfied the requirement for purposes of the foster care placement. But if the parent subsequently completes treatment and needs additional services to regain custody, the court will need to consider whether the state child welfare agency made active efforts to provide these services. ICWA requires not only making active efforts, but documenting them in detail. Simply writing active efforts were made in a dependency petition, court report, or case note does not meet the active efforts requirement. Dependency petitions, court reports, and case notes should report the specific active effort made. Since the court must ensure that active efforts have occurred, staff must detail them in the court record, and not just in the state agency case records. Thanks for your time, everyone. And remember, the National Center on Substance Abuse and Child Welfare has a wealth of resources to further expand your knowledge base on families affected by substance use. Please visit ncsacw.acf.hhs.gov for more information. Also, please visit the Capacity Building Center for Tribes at tribalinformationexchange.org for more resources aimed at nurturing the safety, permanency, and well-being of American Indian and Alaska Native children, youth, and families.